Hello, and welcome to the Three Questions podcast, where we dive deep into the world of wealth management and connect you with industry experts. I'm your host, Wayne Baxter, Senior Executive Manager at One Capital Management. Now, if you or someone close to you is a resident of California and has questions about their estate plan, stay tuned. This episode is for you. Our topic, the three questions California residents should ask before establishing or updating their estate plan. Thank you for taking time to check us out. And if you enjoy this episode of the Three Questions podcast, please consider liking this video and subscribing to our podcast and YouTube channels. Now, studies suggest that over 50% of Americans, and likely similar percentage of Californians, pass away without a will or a trust in place, meaning their estates end up in testate. In California, this triggers a process governed by the state's intestate succession laws, which dictate who inherits your assets based on a rigid hierarchy, starting with spouses and children, then moving to parents, siblings, and beyond. Today, we're joined by a Coral Hills, California-based estate planning attorney, my good friend, Mr. James Stevens. His firm, the Stevens Law Group, focuses on estate planning, will and trust drafting, probate, trust administration, litigation. God, I would not want to litigate against James. Cross-border estate planning, and more. And what we're going to do today, we're going to explore the three questions California residents should ask before establishing or updating their estate plan. James, great to see you, my friend.
Thank you, Wayne. Great to see you as well.
So I got to ask this: how much of your time is litigating estates? I got to ask that right off the bat. My first thing I'm thinking of.
Actually, it's a pretty small percentage because most of our clients have done their estate plans, and when the estate plan is done properly and the family and it's been communicated to the family what the estate plan is, like when people know who's going to get what and why, there aren't a lot of hurt feelings, and there aren't a lot of surprises. So most of the estate plans that we work on, the estates go to the next generation without much litigation at all. And so I would say probably roughly 10 to 20% of our law practice is litigation. And most of those cases are just cases where we are representing a successor trustee, and the successor trustee gets a lawsuit or a creditor's claim or something that kind of comes out of the woodwork that we weren't expecting.
I can't imagine being an attorney litigating issue, James. That would be a challenge. I'll put it there. I know Jay's pretty
Thank you, Wayne. I appreciate it.
It would be, yeah. I hate to go to a gunfight with a knife anyway. Okay, I got to before we even get started any further, I want to publicly thank you. You know, James took a bullet for me a few years ago and traveled across the state of California and did basically acted as my guest speaker at conference. And so, James, thank you very much. My appreciation. How will I ever repay you? I guess.
You're welcome, Wayne. Just including me on this podcast is thanks enough.
Well, it's a little bit less of a heavy lift here at my end compared to what I have put you through, but thank you so much.
Well, for us, if I might interrupt, for us, it's been really good because we've enjoyed getting to work with you and also One Capital Management over the years, especially since you have so many Canadian expats, and we've developed something of a working relationship and a subspecialty with cross-border planning. So just getting to continue to work with you is thanks enough. So again,
thank you so much. And well, here we are. Now, I mentioned in the opening, somewhere around 50%. I don't know if this is how statistically accurate this is. You probably could tell me, but based on my crack research, somewhere half of Californians pass away without a will or a trust in place, which I find unbelievable, given how much we know about how painful an exercise to go. Because basically, what that means is estates have to end up in testate, and oh my lord, even back when in Canada, that was like cautionary tales about estates going testates. So to set the tone for our podcast here today, perhaps you could provide our audience with an outline, the 35,000-foot view of the implications that occur here in California when an estate ends up intestate.
Well, your statistics are pretty close, and they do change a little bit year to year. But yeah, many Americans die without any estate plans at all. And by the way, I love that you use the word intestate. Not a lot of my clients know what that is when they first come in. That's just a fancy Latin word that means dying without a will. And so when Californians die intestate, in the vast majority of cases, their estate is forced into probate. And probate is just it's a court administered process where the court is overseeing the administration of your estate after you're gone. It's also where the court appoints somebody to be in charge of making financial decisions about your estate, like filing your tax return, your last tax return, collecting any life insurance, marshaling the assets, and then the judge deciding who are your heirs, who are the people who are going to inherit everything. And the entire process is public. And all your dirty
When you
laundry
say
is
it's
aired
public, it means that
in that
anybody
court.
can go on, can search this information on their own
Yes, you
publicly.
could go on right now to the Ventura County Court's website or the Los Angeles County Court's website. Our office is in LA County, but we're right on the Ventura County line. And you could look up like the 25 or 30 probate cases that were filed or heard today in just in Ventura
And
County.
all the gory details will be all listed, all the
Yeah,
death.
including an inventory of everybody's assets. Like you could
Exactly.
download, and those are free. Those are public documents that are searchable.
Well, that right there is a warning if you want to keep your personal information private. So basically, what you're saying, if a Bill Smith of Westlake Village or Agora or wherever were to pass away, and he has all of these, owns a house, has a secondary property, maybe in Ojai, has taxable assets of a couple $1 million, and et cetera, and nobody knew anything about him other, they could literally go online and learn everything about what he had when he passed away.
A lot of it. I mean, like account numbers are typically redacted in
Yeah,
court
yeah, but I'm
filings
talking
because we don't want to disclose account numbers. But yeah, you could find out basically what the person owned, when they died, and how much each asset was worth on the date of death.
right. And I don't know if all families want that information out there.
No, most people don't.
All right. Well, okay, so we're going to be discussing today the 3 questions California residents should ask before establishing or updating their estate plan. Now, our questions are from the perspective of the spouses, no, basically from the family of the deceased. So
Okay.
we're gonna look at it. Maybe not just spouses. I'm going to say spouses. It could be spouses or children,
All right.
loved ones. But let's get right at it.
Sure.
Uh, on average, question number one, James, on average, how long should, and that's a very subjective word, should a California probate case take?
That is a great question. In most cases, a probate's going to last at least 9 months in California, but that's rare. It's really difficult to finish a complete probate from soup to nuts in 9 months. Most cases take anywhere from 1 to 2 years, and I would say the average is probably around 13 to 15 months. And there's a reason for that because everything takes time. Also, there's a really long line at the courthouse. So, for example, if I wanted to file a petition for probate today in LA County, the court probably would accept my filing today, but probably wouldn't look at it or schedule a hearing for 3 months. And so, sometimes 2 months. LA County, coming out of COVID, has done a better job of getting probate petitions on calendar more quickly. But it still does take, it takes a couple months' time just to get the probate petition on. And in that time, nothing's happening. Nobody has access to the safe deposit box. Nobody has access to the bank accounts.
Or the investment
Some
account?
yeah, sometimes the properties are just sitting vacant or tenants are still in properties. Nobody is, but there's this lag time. And it happens in most of the cases. You could go to court early if you wanted to on an ex parte petition to get temporary orders. If there's an emergency situation, like there was a pending house sale that an escrow was supposed to close and the person died 3 days beforehand or something like that. But in the vast majority of probate cases, yeah, it's 2 to 3 months just to get the first hearing date. And about 12, 15 months is kind of like an average probate.
Okay. You just opened the Pandora's box of questions here. I knew this was going to happen. Okay. First thing I got to ask. So I remember I mentioned the word investment accounts.
Mhm.
So under the scenario where there has to be a probate. And let's say the major breadwinner passes away and now there is no income coming in, and basically the loved ones, the next of kin, as they say, is relying on uh getting paid, supporting themselves based on what is in that individual person's investment account.
Okay.
uh in that case, I'm not talking IRA, I'm thinking taxable assets, right?
Sure. Yeah, an after-tax account. Yeah.
Exactly. So is that a situation where you can, what's the word I want to use? Usurp the process to the extent that you can go to a judge and say, client needs money from this account. Is there a way of expediting that, or does you have to literally wait for that entire probate case to go through before anything can be done with
There,
that?
there could be some ways to get around that time that delay. There's something called a family allowance. I don't want to dive too deep into it, but there's a family allowance that's available to surviving family members. In the case of a surviving spouse, this is usually not a problem because oftentimes the spouses, both husband and wife, or both spouses, are on the
They're
account
joint
together.
owners. They're joint owners. I
Yeah,
was
they're
trying to,
joint owners, and like you said, with an IRA, typically there's a spousal
it's not a
rollover
problem as a
option.
beneficiary. I'm just basically fishing here a little bit, James, and
Yeah.
just saying, where is the scenario where the person kept everything in their own names, and all of a sudden it's like, wait a minute, we need to get access to that money. So there
Yeah,
are
that 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 can be a problem. That typically requires if the amount is over the statutory threshold for probate, it's going to require a probate, and you're going to
oh
have to go to the
boy.
court and seek either letters testamentary when there's a will or letters of administration when there's no will.
So that's a cautionary tale for anybody listening about how to own assets in California. But again, then they said we're a community state, and sometimes people keep money in their own names, and boy, oh boy, we better have a trust set up, is all I can say. I'm just thinking again, you kind of talked about some of the factors, but that can delay things. But are there any other factors you would say that can delay a probate case in
Oh,
California? And
yeah.
is there things that residents can proactively do to minimize these delays?
Okay, well, those are two great questions. I'm going to try to answer the first one first. Yeah, there are a lot of things that cause delays, especially after the probate gets up and running.
Right.
One would be like a common example would be a property that has to be sold, and one child says, I want to keep it, and the other child says, oh, no, I want to sell it.
That's
Now there's
common.
got to be some agreement among the parties as to what to do with this property. And if you're trying to sell a distressed property in a down market and one of the children is objecting to it, all three of those things will conspire against you to not be able to close the probate in a timely
So
fashion.
getting everybody on the same page.
Yeah. Other things would be like, when you have a taxable estate, when you have a federal estate tax, you need time to file the federal estate tax return. Now, currently, the state tax exemption amount is 13.9 million for people
Mhm.
passing away in 2025, and that's going to change. That might be another episode to talk about federal estate tax.
Undoubtedly,
But
yes.
in those larger cases where you're probating one asset, but there are other assets outside of probate that require the filing of an estate tax return, you've got to wait at least 9 months before the estate tax return is filed. And most estate tax returns are put on extension and filed 15 months after the person passes away. And then the other thing that causes delays I would say that I see more often than not are just the disputes among the children. Like, and it can be really complex disputes, like the ongoing management of a family-owned business. Like if there's a multi-million dollar business and each of the family members is employed by that business and has minority interests in it, there might be a dispute once the patriarch or matriarch of the family who owned the majority interest dies. Or they could be really simple stuff like who gets grandma's jewelry. And all of those things cause time and delay, which cost extra money, which just makes it harder to go through the probate process.
And I'm just going to jump out there on a limb here. And is that where sometimes litigation comes into play?
Yeah, absolutely. So anytime there's litigation, and the litigation usually comes from a kid who was left out and didn't know it, or
Mhm.
sometimes it just comes out of left field, like a creditor will file a claim. I've had plenty of probates that I've done in the last 25, 30, 28 years that I've been an attorney, where we just got a claim just came out of left field. Like we didn't even know that this person was owed money, and they filed a lawsuit against the estate after we opened the probate.
Hmm.
And sometimes those claims come in from taxing authorities. I worked on a case years ago where a guy didn't pay his property taxes for like 7 years. And he legitimately deferred the payment of those, but we didn't know that those were due because he never told any of his family members that he took advantage of that property tax deferment plan in California. And after the niece inherited a property which she intended to keep, she actually ended up having to sell it because the property tax bill was over $55,000.
Rude awakening.
Yeah,
So
and had we
communication,
known about that before the probate started, we could have proactively dealt with it. Or had the gentleman done his planning with an attorney during his lifetime and disclosed that, that could have been made part of his estate plan, accounting for that creditor. But you know,
so I find it remarkable, going back to the beginning of our episode here, that this applies to 50% of the residents of California. That's
give or
unbelievable.
take, yeah.
That's pretty remarkable. Okay, let's go on to question number two, James.
Okay.
Okay, this one for you will be like easy as falling out of bed. How do trust assets avoid probate court?
Trust
Your
assets or
thoughts,
all
please.
assets? Well, there are some assets that are never put into a trust, like a 401k. And so if anybody owns a 401k or an IRA, those are going to avoid probate because
Yes.
they have a designated beneficiary. And the designated beneficiary is a contract that the plan participant had with that third party bank or that financial institution that says, when I die, pay my retirement account over
Exactly
here.
right.
Life insurance works the same way. And then there's some other assets that will also avoid probate without ever being in a trust, like joint tenancy property. So if two spouses own joint tenancy together with right of survivorship, that right of survivorship says that when one spouse dies, it just goes to the other spouse by right of survivorship. And so there is no probate. And joint tenancy works really well when the first spouse dies. But remember, when the second spouse dies and there is no joint tenant, it goes into probate at that time. And so that's why we typically in California recommend trust. And how you avoid probate on a trust asset is you step one, you create the trust. Step two, you fund the trust. And funding the trust means taking ownership of whatever that asset is, be it real estate, a car, a bank account, and you transfer ownership of it to the trust. And a lot of people mistakenly think that if you create a trust, and let's say you have this beautiful 20 or 30 page document, right?
I know where this is
That
going.
just by listing the asset in your trust, you're going to avoid probate on it.
It's, I swear to God, James, I was on a call yesterday with somebody that was referred to me, and that's exactly what appears to have happened. They created the trust
Hmm.
document,
Yeah.
but I don't know for certain because
Uh-huh.
it was somebody that was referred to me. It's not my client per
Yeah.
se, but we were talking about whether or not they had established a trust.
Did
And
they include like the account number or a description of the property in the trust?
they basically outlined the types of things that
Yeah.
should be held in the
Yeah.
trust. And I don't want to get too far into the weeds here, but
Sure.
it looks to me like you just said, they thought just because they created the trust that there was no, like with us when we have a client, and I just did one here recently with a clients of mine. If they're listening, hello, that you know who you are, where they actually we got them, begged them for months, years, they know this, to get their trust set up. They finally did, thank you. And so once that was done, we got their attorney and them to send us a copy of their trust, and we literally set up a trust brokerage account.
Yes, that's exactly what you
And
would do
then
in
we
that case.
journaled the shares that they held in their joint account
Hmm.
over into the trust. It's like
Yeah.
picking it up, moving it over, putting it here, moving from one box to the other. In this case of the person I spoke to on the phone yesterday, I don't think that second part happened, which
Yeah.
I could go
Um,
on.
I'm curious on your case. Now, you said it was a married couple, so hopefully, when they took the assets out of their individual names and put them
No,
into the
it
trust
was a joint
account,
account owned jointly. It was a
yeah, own a joint account, and now it's a trust account. So it'd
yes,
be husband and wife, trustees of the Smith Family Trust, for example.
correct.
And hopefully there's a declaration in there that says it's community property held inside
Yes,
of the trust, because that way, for income tax purposes, the community property would receive a double step up in the income tax basis on the death of one spouse. So the surviving spouse could inherit things through the trust and avoid probate, but also get that income tax benefit. So hopefully that was done in that case.
exactly correct.
Yeah.
So
Well,
anyway, yeah, I think in this other case they did the trust. They listed the types of investments, but I don't think the uh, the other the client's other advisor, I don't think they did. I don't know. But
Yeah, and if you want to trust, if you're a Californian and you want to trust asset to avoid probate, then it needs to be legitimately owned by your trust. And that doesn't mean listing it in the trust, which is helpful because it gives you an
but you
idea
have to
that
actually
the
be able
person,
to show that the assets are held in a, from my perspective,
right?
they need to be held in a, I'm just going to put them out there. You're welcome for the free advertising. Schwab brokerage
Yeah,
account listed, like you said, the Smith Family Trust
yes,
circa,
yes. And you can pick you
April
can,
2024 or whatever.
yeah. And you can pick your financial institution, the Schwabs, the Fidelities, the big brokerage
Exactly.
houses of the world, right? But it needs to be a trust account. So I'll give you an example. Like we had a client who listed their house. Well, not a client of ours, somebody for whom the next of kin came to us, and they said, "Hey, Dad wrote the address of his house in his trust. Is that good enough?" And we said, "No. For real property, what you actually have to do after you create the trust is you create a deed."
Yeah,
And the
exactly
deed
right.
transfers everything from, let's just say, John Smith, an individual, to John Smith, trustee of the Smith Family 2025 Trust. And you record that deed with the county recorder in which the property is located. For a car, if you now you don't always put cars in trust, but if you want to put an automobile or an RV, let's like say you had a really
Collectible
expensive camper
or
van,
something. Yeah.
right? And you want to put that in the trust. You would actually register the trust's ownership of that on the pink slip with the California Department of Motor Vehicles.
Yeah.
If you have an after-tax bank account and you want to put that into your trust, listing it in the trust is helpful, but actually going down to the bank or going like perfect example, One Capital Management. If you got an investment account at One Capital Management, it needs to be transferred from the
Well, we
individual
just
owner
talked about a couple
to the
minutes ago.
trustees of the trust. Yeah.
Okay. James Stevens is joining us here. My good friend and estate planning attorney with the Stevens Law Group in beautiful, and I mean beautiful, Agoura Hills, California.
We love it here.
Yeah, James' office is right at the foot of Ladyface Mountain. You would not believe it if you saw it. It's an incredible spot. Okay, let's move on here. I got one more question before we get on to question number three,
Okay.
and that is about mistakes. People here, what am I
Mhm.
doing right? Well, maybe we should educate and inform here a little bit more. What do you think is the most common mistake that people make when they're setting up the trust that accidentally forces an asset into probate? What is the biggest mistake that you see people make?
Well, I'll give you a
And
couple,
that's
and the
just
biggest
Wayne.
one
This
is
is
the.
an unofficial question. This is me.
I appreciate that. I'll give you two. The one answer is what we just talked about. It's creating the trust, but then failing to actually fund the trust.
It's
When you record a
incredible.
deed for a piece of property, or when you
Like
change the
building a
title
house
to
and
a
not
bank
moving
account.
into it.
Yeah,
I'm sorry.
yeah.
There's an
that is the
analogy for you,
biggest
James. I
mistake we
can use that
see.
one free of
Yeah.
charge.
But the other mistakes that we see oftentimes is failing to back up the trust with a safety net. So a lot of people will go online and create their own trust. And I have no problem with that. I think it's good that there's some low cost resources out there for Californians to try to create their own trust
Makes
as
me
a means to
shudder.
not only
Makes me
avoid
shudder.
probate when you
Makes me
die, but
shudder.
we haven't even talked about this, but it also helps you avoid a conservatorship if you're alive but incapacitated. And if you want to know how badly a conservatorship can go, just ask Britney Spears
Britney Spears.
and what the last 14 years of her life was like, right? So having a trust is generally a good idea. But a lot of people, especially those who try to do it themselves, fail to back it up with a safety net. Now, Wayne, I know that you grew up playing hockey, but I'm going to give a baseball analogy because
All right, fair enough.
I grew up watching the LA
There's a
Dodgers.
homage. It'll be a homage to my wife Susan, who you know, who is a fairly big Dodgers fan. So
Yes,
away we go.
absolutely. Props to Susan as well. When there's a wild pitch in baseball and that ball flies past the batter, past the catcher, and past the umpire, it hits what?
A net or the back of the
Yeah, it
basket.
hits the backstop. Every trust in California needs a backstop, and we see a lot of people who fail to give a backstop to it. And that backstop is usually composed of three or four documents. One is a will. Now, people always ask, well, if I have a trust, why do I also need a will? Well, the will has a provision in it that says if I forgot to put something into my trust, then when I die, the executor of my will, who's probating this one asset, has to give it to the trustee of my trust. So it funnels assets into the trust. The second part of that safety net is usually like a financial power of attorney. And what the financial power of attorney says is, hey, if there's an asset that cannot be owned by trust, and this is a big a big pitfall that I've seen a lot of people fall into. If there's an asset that cannot be owned by my trust and I'm alive but incapacitated, then
Right.
somebody needs to do that. The biggest pitfall we see is people have a trust and they put their house in it, but then they have this $2 million IRA. The I in IRA stands for individual. That's your way of remembering that
With the
an
beneficiary
IRA
being
can
the
only be owned by
spouse.
an individual. It cannot be owned by a trust, otherwise it becomes immediately income taxable.
Right.
So if you have this asset that's outside of your trust, that's the bulk of your wealth, and you don't have a safety net for it, like a financial power of attorney to back up the trust, then you've got some very incomplete estate planning. And then the third document is a nomination of conservator. So if a court proceeding ever became necessary while you were alive but incapacitated, the nomination of conservator says, hey, who is ever acting as trustee of my trust can also be my conservator. And that way the court isn't picking somebody at random, they're picking the person that you want to be making financial decisions for you.
Right.
And
A
we see
huge
that
thing.
lack of a safety net or that lack of a backstop in a lot of cases, especially with do-it-yourselfers, or especially when people went to a law firm that doesn't specialize in estate planning and they thought, oh, well, I'm just going to charge this client to do a trust. And they don't realize that there are some backup documents, there's some safety nets that go along with it.
Power of attorneys.
Powers of attorney. Yeah.
I could go on. We're going to defer on that today. That's a whole episode.
Yeah, that's a different episode.
By the way, I should also thank you. Now that I think of it, you mentioned my much better half, Susan. So recall, I think it was you who helped coach her on her civics test for citizenship. Yeah,
Yeah, that was fun. I enjoyed that actually. That was
yeah.
that was a lot of fun. And she passed with flying
Oh
colors. That was
God,
great.
they stopped after 6 questions. Yeah, exactly. So
Yeah, 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 yeah. She had that. She had it
yeah,
down.
thank you so much, James. Okay, on to our third question. These are
Yeah.
the three questions you should ask either before you establish or update your California estate plan. Question number three, and this is a good one. Can my trust safeguard my child's inheritance from their future ex-spouse? This is where it gets really interesting. So, James, over to you.
Short answer, yes. Short answer, yes. Longer answer, how much time we have left in this episode?
Well, we have as much time as you need, and that answer just about broke my heart because it reminds me back when I had my radio show in Toronto and I had a guest on
Uh-huh.
set up their big question and they answered it yes, and I just went, yes. So
So yes, you
anyway,
can. Yes,
please
you.
elaborate on the
Oh,
yes.
okay. So here's what you would do. So you absolutely can leave a trust to your child that would be protected from their future ex-spouse.
Mhm.
And it would be very similar to the types of trust that we do for like what's called a special needs trust, or that's a trust for a special needs child, or a spendthrift trust. That would be like for an adult child who spends money like a drunken sailor. It would be kind of similar to that, and it could be a lifetime trust for the benefit of the child. Now, there's some limitations. You can't, the child can't contribute their own money to this, but we could incorporate these terms into mom and dad's estate plan. So if we were writing a trust for mom and dad, there are two big ways that you can leave stuff to kids. You can either leave it to them outright as soon as they reach the age of majority, or you can put it into a trust that lasts for a period of time. And what you would do is you would say, all right, this child's inheritance is going to go into a sub-trust. That's a trust under the family trust.
Mhm.
And that trust is going to be for the benefit of this one child for the child's lifetime. And then you put some specific provisions in there that says, um, this is my child's separate property inheritance, and it will stay that way as long as it stays inside this trust. So even if your child gets married and fails to do their own estate plan, or gets married and fails to do a prenup, what goes into that trust would conceivably be protected from that child's future ex-spouse. Now, you got to be careful. And you got to put you got to put some very specific language into it,
Yeah,
and the
that was
trust would have
exactly
to
what
be
I was going to
irrevocable.
ask
So there's a
you.
cost benefit analysis, but the short answer is yes.
Okay, you just led me into segue, probably intentionally, hopefully, into my follow-up question, which is how specific do these provisions need to be to ensure, and I'm thinking about divorce courts in California. Like how
Mhm.
specific do these provisions need to be to hold up in the divorce court? So, there's a divorce and now the ex is coming back and saying, well,
Yeah.
he had access to $4 million, and
Uh-huh.
I feel I
Oh,
should get a share of it. Like, how specific do these provisions have to
sure.
be to, ensure to avoid the war of the roses, if you will?
Okay, so there are some technical things that you'll want to make sure your attorney does. Things like there needs to be sometimes it's called a spendthrift provision or an anti-alienation clause in there, something that says, hey, this is really for my child and my child can't assign these rights away.
Hmm.
Um, and then there's just some other things that are just general instructions that you would leave in there and some planning things to consider. For example, you might not want to make your child the trustee of their own subtrust. You might
Yeah,
want to have a neutral third party in there. Because if you let, how do I say this? If you let the proverbial hen guard the proverbial hen house,
right.
then a judge, a future family law judge, might be more willing to unwind that trust. So if you were going to put in a neutral third party trustee, it's going to be harder for a family law judge to go to somebody who's not beholden to your child to say, hey,
Yeah.
unwind this trust. And that neutral third party trustee can say, I can't. The trust became irrevocable when this person died. I've been tasked with managing it according to these specific instructions. And these specific instructions say I can't use it over here in a family law
It's
case.
incredible
Now,
that you even bring that up, because I'm actually had a conversation with a client of mine yesterday morning
mhm,
where this potentially is a problem. And I did instruct her, begged her,
mhm,
urged her to go have an appointment with her estate planning attorney for
sure.
just you almost created the case study, potential risks down the road. So I'm glad you brought
Okay.
that up.
And I want to be really careful here because these types of trusts are not entirely bulletproof,
Right.
right? Because any attorney can tell you that most judges in California sit in equity, and they have a lot of discretion to unwind trusts when the facts and circumstances call for it. But there are a lot of things that you can, as the client working with an estate planning attorney, put into that trust to make it more likely that it will withstand scrutiny later on. And and that is oh man, that is a deep dive conversation.
Fair
We're not
enough.
gonna we're not gonna cover it here in the next few minutes,
You
but that is
know,
a deep dive
for
conversation to have with every estate planning
you and
attorney.
I knew this was going to happen.
Yeah.
You said to me, Wayne, how long do you think this podcast is going to take? Oh, 20, 25 minutes. And here we are, almost about 40 minutes in, and we got to we
Yeah.
should get us
Yeah.
wrap this
Okay.
up.
Yeah, we got to wrap
So
this up.
I'm gonna, just before we wrap up, I'm gonna ask for the sort of the parting
Okay.
big idea here.
Yeah.
Uh, so for those folks listening that are in California listening, and folks across the country, there's some great tidbits in here, regardless of whether you're in the United States or even in Canada, because some of the things that James you mentioned are also applicable in Canada. For example, the ideas of having beneficiaries on your retirement account and so on. So great information there. But what is the one estate planning step that every California resident should take right now, regardless of their age or wealth, to protect their family's future? What would you recommend?
Do I have to limit to one or can I give you two?
Let's see how long one
Two
goes, and
quick
I'll
ones.
give you.
One, work with a reputable law firm that specializes in estate planning to get the estate plan written and documented, right? That's really the most important thing. And most of my clients, especially those who own real estate in California, it's going to be a trust-based plan, meaning the trust is going to be the primary document, and then the wills, powers of attorney, nominations, conservator, and we haven't even talked about it, but the medical and personal care decisions, all of those things are also incorporated into the plan. And then step number two, and I actually tweeted about this on Monday, or I posted on X on Monday, was an article from the AP News that was talking about how to speak with your family about your legacy. And really, step two is tell your kids, talk with your spouse, talk with your kids about what you're doing and why, because the best estate plans, the ones that are least likely to be challenged and the ones that are most likely to hold up under scrutiny are the ones where everybody knows who's getting what in advance and why. And and there's a difference between being fair and equal with your kids, right? And maybe that's a different podcast too. You can be unequal and still fair. with your kids. And
Yeah,
if your
and
kids
'cause
know
that's the
what
thing
they're
with
getting and what to
family.
expect, that goes away. That goes a long way towards avoiding hurt feelings after you're gone.
Let's agree on this: is that estate planning unto itself is much more of an art than a science here. I mean,
Hmm. Yeah, and it's
okay,
a conversation, and it's an ongoing conversation. It's not a static. Hey, we just created some document, it's done. It's a conversation that takes place over months, if not years.
yeah. I mentioned this on a podcast I did a little while ago with one of your colleagues, and I mentioned that we took quite a trip actually, my wife and I, and I was literally sitting in the airport waiting for our, get on their flight, and I thought, I better let the kids know that we're going, where we're going, how long we're going to be gone, and who our successor trustee is.
Yeah, yeah, yeah,
And
absolutely.
so I sent this long text, and I, at the bottom of it, said, please confirm receipt, because I don't know about your daughters. I know you have four daughters. I don't know
Yeah,
how well they are at communicating when you send them a text, but I made sure that I got a confirmation back from them that they both read what I sent them, and thankfully I did.
yeah,
Uh,
that's a good idea.
okay, you know what, James, we're going to wrap up here.
Okay.
I know I had more I wanted to go over, but we're really keeping you really much longer than I planned to. So, um, I know we have folks watching on our website, but there are lots more folks listening to us on Apple or Spotify. Um, we could go back and forth forever, but if somebody wanted to get a hold of you, is listening today or watching today, what is the best way for them to reach out to you?
They can call our office, and I don't know if you're going to have my phone number at the bottom of the screen here, but
Yes, I
it's
do. I got it right in front of you. Definitely.
818-707-8200. That's in California. They can also reach us online. They can message us through our website, www.stevenslawgroup.com. That's Stevens with a PH, so
Yep.
STEPHENS lawgroup.com. And they can message us through the website, and we'd be happy to answer questions that they might have.
James, thanks so much. Thanks for coaching my wife Susan on her civics course. Appreciate that. Appreciate everything you do for me. Great knowing you, and definitely we've come up with 2 or 3 more episodes that we can have you back for.
I would love it, Wayne. Thank you very
It's a
much.
lot of fun. So James Stevens, again, is located in Agoura Hills, California, and the Stevens Law Group focuses on estate planning, probate, trust administration, litigation, and cross-border estate planning. James, thank you so much for being with us today.
Wayne, thanks again. See you at the next time.
I look forward to bringing you the 3 Questions podcast, and I hope you find them educational and informative. Please consider liking this video and subscribing to our YouTube and podcast channels. And to receive notification of when our latest episode has been posted, please click on the notifications bell. Lastly, to schedule an online Zoom consultation with me to discuss your wealth management needs, please click on the link in the description box below, www.onecapital.com/meet with Wayne. Thank you, and we will see you soon.